Hi, welcome to today's town hall. We are so excited to have everybody here. The town hall today that we're doing is called The Heart of the Matter, Copyright AI, Training, and LLMs. This is actually CCC's second town hall that's focused on AI. We did one back in October. And this time we're going to focus on how copyright protected training materials are being retained, used, and reused in large language models, or LLMs. Today, we'll talk about the technology behind LLMs to help us understand how and why copyright protected works are copied and used in training and other parts of the process, and also why it matters for creators, publishers, research driven companies, academic institutions, researchers, and any of us who use these systems. Because these days, it seems that the uses are getting farther and more widespread, and it's a really good idea to take this moment to understand the technology and how that actually does implicate copyright rights. And so today we are joined by a really expert panel, and I'm really happy to have them here today. I'll do a brief introduction of them. So first is Dr. Babis Marmanis, who is CCC's Executive Vice President and CTO. He is author of Algorithms of the Intelligent Web, which introduced machine learning to a wide audience of practitioners working on everyday software applications. He has a PhD in applied mathematics from Brown University. So welcome to Babis today. We next have Professor Noam Shemtov. He is the Chair in Intellectual Property and Technology Law at Queen Mary University of London. He has led research products and studies funded by UK research councils and by such organizations as CSAC, WIPO, the European Patent Office, and the European Space Agency. And then we have, last but definitely not least, is Professor Danielle Gervais, who is Milton R. Underwood Chair in Law and Director of the Vanderbilt Intellectual Property Program. He focuses on international intellectual property law and the law of artificial intelligence. He is editor-in-chief of the peer-reviewed Journal of World Intellectual Property, and he's also written a novel on AI forever, if you're interested. And with those introductions, I'd like to get us started on today's program. We have a lot to cover and wanted to start with technological aspects of this. So I'm going to say we've heard a lot about AI, not as much about how the AI technologies work, realizing that there are a lot of different kinds of technologies. Today, we're focusing mostly on LLMs with a little bit of explanation, Professor Shemtov, on diffusion models as kind of a comparison. But first, Babis, could you walk us through how some of these technologies generally use and store materials like books and articles?
Thank you, Katie. Yes, in order to answer that question, let's take a step back to put things in perspective. Humans communicate verbally or in written form by placing words in sequences. The rules about the sequencing and the specific form of a word are dictated by the specific language, for example, English. Words themselves are either sequences of characters from an alphabet or single or multiple characters, symbols, as is the case with Chinese and Japanese languages. In computing, we call the human languages natural languages. And when we're studying the processing or understanding of our languages, we refer to that as natural language processing and natural language understanding, respectively. The former term is more prevalent, and you will often encounter it by its acronym NLP. Next slide, please. So as far as textual content is concerned, books, articles, and other text-based artifacts, compilations of word, these are compilations of word sequences. However, computers cannot directly understand the words that we're using, the words of our language. Computers work with numbers. That's an essential part of the software architecture for all software systems that process text, and therefore for all AI systems that do so, is how to represent that text with numbers so that the required tasks of the system can be performed. Next slide, please. There are many steps involved in producing an efficient numerical representation of text. At a high level, we can identify the first step in the transition from natural language words to numerical representation of words with what we call tokenization. Depending on the exact goals of the system and the overall design, tokenization entails many steps, from simple separation of words based on white space or other separator markings to lemmatization and stemming, and all that is part of what is known as text normalization. The important part of all this for us here is that through that process, the natural language text produces a set of tokens that will be used subsequently to represent all the text that was found in a book, an article, or any other document. Once the tokenizer identifies all the tokens that we need, it forms so-called vocabulary, which you can think of as a list where each member of the list has a number associated with it. Now we can use that vocabulary to represent any raw text input as a series of numbers that indicate which token should be used. The modern option for tokenizers is a class of tokenizers called that performs subword tokenization, which produces sets of tokens that, as the name suggests, are smaller than words. We can mention here that OpenAI and Azure OpenAI, as well as many others, use a subword tokenization method called byte pair encoding for their generative pre-trained transformer, the famous GPT-based models. Byte pair encoding is a method that merges the most frequently occurring pairs of characters into a single token until a certain number of tokens or vocabulary size has been reached. The larger the vocabulary size, the more diverse and expressive the text that the model can generate. A distinct advantage of subword tokenizers is their ability to handle what's called out of vocabulary words, or words that you haven't seen while you were creating the tokens. In sum, tokenization allows us to map raw text onto a set of numbers and a set of numbers back into text. That mapping is lossless. If you encode a string with your tokenizer and then decode with what you get from the encoder, you will get back exactly the text that you used as the input. At this point, it's important to note that regardless of the specifics of the tokenization approach, these pre-processing steps take place and copies are made. Next slide, please. Now, tokenization is the first step towards a numerical representation of the sequences of words that occur in text. And although it is necessary, it is not sufficient, especially for the kind of AI applications that have taken the world by storm in the past few years. For these applications, we need what are called dense representations. So enter the world of embeddings. These are high-dimensional vectors. You can think of vectors as being rows of numbers or columns, for that matter, in an Excel spreadsheet. However, the dimensionality of these vectors is much smaller than the size of the vocabulary, and therefore much smaller than the dimensionality of the vector representations that we can build based directly on the vocabulary. They are also dense instead of sparse, consist of real values instead of integers, and they turn out to be far more effective and efficient for all NLP tasks. It will take me more time than we have to explain word embeddings in detail. Luckily for us, I don't have to. The important part is that modern AI systems create and store contextual word embeddings that capture the relationship of words in long sequences. The transformer architecture is all about attention. As the groundbreaking paper by Vasvani et al. Described it, attention is all you need. We often hear people say, oh, there are no copies after training. There are only parameters, probably referring to the weights of the neural network. But what they fail to understand is that these parameters define the probability distribution over enormously large vector spaces. If you take 2 words from a vocabulary of 100 words, then there are only 9,900 possible combinations. But if you take 1,000 words from a vocabulary of 100,000 words, which is a good example for state-of-the-art LLMs today, the number of possible combinations is astronomical. And the only combinations that would have non-negligible weights, that is, probability of occurrence, would be the ones that were observed during training. So in a number of cases, this will result in a lossless reproduction of materials that were used during training. The more unique the material, the more likely for that to happen. As an example, ChatGPT in its GPT 3.5 incarnation used to regurgitate Dr. Seuss by simply prompting it with the text, "All the places you'll go." That was no accident. Next slide, please. Large language models, as they're called, go through various stages of maturity, from inception to production, We can identify 4 major stages in their evolution, as you can see on this slide. Everything after pre-training is essentially fine-tuning. The focus in the pre-training phase is volume, whereas the focus during fine-tuning is on the quality of the material used. However, in all fine-tuning stages and all downstream applications, the knowledge stored in the LLM is leveraged. Perhaps the most interesting area of fine-tuning is for span-based applications. That entails generating and operating with representations of contiguous sequences of tokens. Example applications in this case would include named entity recognition, coreference resolution, questions and answers, syntactic parsing, and so on. Next slide, please. In summary, LLMs are able to reproduce original works. They form internal representations of the text that they were trained on in purpose-built vector spaces. Given the appropriate input as a trigger, they could reproduce the original works that were used in their training. I hope that helps to set the stage for our discussion here today regarding the use of textual copyrighted materials used in AI systems, Katie.
Thank you so much, Babis. That was really interesting. And I would like to turn to Noam next about looking at a different model briefly and how that might work and how the copies are made and used and the copyrighted material that's at issue there. So I'm going to turn the floor over to Noam to talk a little bit about that.
Thank you, Katie, and thank you, Babis, for the explanation about transformer models. I'm going to do a shorter work on the diffusion model, a little bit about the technology, and then perhaps a number of examples as to how does it actually work, and then I'll move on to the question of copy, the making of copy and retention of copy. So in terms of a definition, when we're thinking about diffusion models, they work slightly differently. So it's not really, the key is not about a relationship between different elements in sequence. Here we are, what we're talking about is models that transform data from noise distribution step by step into a sample of the target distribution. The key characteristics, what they do is essentially to iteratively add and then reverse noise, gradually and progressively refining the generated output. They're flexible in generating complex and high-end quality outputs. They're especially useful in the context of image and audio. Then it comes as a bit of a surprise in terms of application. What we're talking about here is high-fidelity image and audio synthesis, and then and really enhancing creativity in art and design. Next slide, please. Key differences between transformer and diffusion models. Transformer models analyze and generate data based on relationship between elements in a sequence, as I was stating before, and diffusion models progressively refine data from a noisy state to a coherent output. So noisy state, sometimes it is referred to as denoising. In terms of performance, transformers excel in tasks requiring understanding of context and sequence, hence text. Diffusion are mainly about image and audio, and therefore in terms of application, the applications are somewhat different. Transformers are pivotal in natural language processing applications, and diffusion models are used in creative and generative tasks that require high fidelity and innovation. Now, let us look at perhaps the way it is put into practice. It's just a couple of examples to the use that we may put diffusion models. Next slide, please. Actually, this is not a slide. This is what we'll do now is to frame the web page. We are back here. Yeah, thanks. So if we can just make that happen to frame the web page of Meta, the AI tool, which is make a video. This is a diffusion model, and if we will just scroll down slowly, so this is an example for very short video. You can see the prompt there: a dog wearing a superhero outfit with a red cape flying through the sky. So textual prompt on one side, and on the other side we get this short video. What we have here is a teddy bear painting a portrait. I'm not explaining what it is. This is actually the textual prompt. That's the only thing that you need in order to create this video. Thank you. So that's in terms of so an example in terms of video. Now, if we move to the world of image, next slide, please. Yes, that may look a bit puzzling. And then the next slide, please.
I think we may have lost Noam for a moment there. So while we're waiting for him to reconnect, why don't I turn to Babis to ask you a follow-up question while we get Professor Shemtov reconnected here. So my question for you is: you talked about the copies and how important are copies in the LLM models to make these copies, and how are they related, together?
Yeah, there are several ways in which copies are made. The first is the obvious one. In order to process all this text, you need to make copies from one place to another as you're pre-processing all the text. The other one is related to word embeddings that we mentioned earlier today. So the word embeddings are not just representations of a word in a large vector space, in a high-dimensional vector space. They are, in essence, the representation of a word in every context that word appeared in. And therefore, that's a very powerful way of capturing the order in which tokens, in which words of the original document are preserved within the system. And then, of course, let's not forget that all these parameters, as I mentioned earlier, that we're talking about, are these weights are simply determining the probability distribution of a particular sequence to occur. But since there is so many words available in the context window, and I'm not going to get into now what the context window is, but basically think of it the chunks that the system processes the text. The probability of the specific sequence to appear is only high if this kind of sequence has been seen during training. So in a way, this is also a copy. It may be a copy based on a probability distribution, but if you are able to recreate the sequence, it's immaterial. Think about compression, for example. There are two kinds of compression. There is lossless compression, in which nothing's lost, and there's loss compression, which achieves highest compression rate. An approach similar to what the LLMs do would definitely qualify as a loss compression. So copies are made and are made at various stages of the development and operation of an AI system.
And do you want to make any kind of comparisons to other types of technologies that we've seen before? For example, like simple indexing that you might have seen before about indexing works versus this kind of use.
Certainly. Well, most people are familiar with indexing. It's been with us for a very long time, 2 decades, even more now. Do you remember Alta Vista? I'm old enough to remember Alta Vista. So indexing is basically decomposing the documents, deconstructs the documents, and keeps references of terms that occur in a particular document, and then there's ranking related to that. But you cannot recreate a document based on the information that you have on an index. That's impossible. Conversely, in an LLM, you can recreate under certain conditions. You can recreate what you have seen for the reason that we mentioned earlier, that the content has not been lost, has not been deconstructed. It has been represented in a very sophisticated way within the LLM.
Okay, that is it's definitely a difference and definitely an interesting comparison, I think, to see all of these different kinds of technologies, both in the AI world and the ones that we've seen before. And so while we are thinking about that, I would like to turn a little bit to the copyright piece of it and how it fits together with that technology. So having all of that background that we've done, we also wanted to talk about, you know, how does technology and copyright work together? So technology has been around forever in different forms, since copyright's been around for a long time, and they've both kind of worked together and coordinated, and there's been the ability for copyright to evolve and be flexible over time. So I wanted to, before we specifically talk about the AI implications of the technology, maybe ask Professor Gervais, how have you seen copyright applied to technology as it has marched on through the years, and some examples of that you think that could show how it does flexibly evolve?
Well, thanks, Katie. So I think the main point is that the entire history of copyright is a history of adaptation to technological change. And you asked what I saw. I think I need to go back. I'm not quite that old. I need to go back even further in time. So, the very basic first copyright statute in the 18th century was really just about creating a marketplace for books, right? So that authors and publishers could work and earn a living from their work. But then you see an adaptation of copyright by adding a public performance right, because music and theater was performed live. And then after that, technology really kicks in. So it starts as early as the player or piano, which was considered to be a new form of reproduction of music, and the right was created for that. Closer to us a little bit, the invention of radio necessitated the creation of a communication to the public right, or in the US, it's still part of the public performance right. But it's essentially a recognition that an existing right applied to this new technology, and then later applied to cable retransmissions as well. When cinema was invented, a new category of copyrighted work was created as a result. And then a few decades later, computer programs were considered to be literary works and added to copyright. Then if we move to the mid-1990s, when the World Wide Web emerged, the world came together very quickly in 1996 to adopt two treaties in Geneva, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty, WCT and WPPT, to create an exclusive right of making available, which was the main novelty of the internet in terms of copyright. And these instruments also protect what we call rights management information, which is relevant in some of the lawsuits we might discuss later in the town hall. Now, if you place all these changes and adaptations on the timeline, it's quite easy to see that the new exceptions were designed to ensure that authors would have a say, or at least be compensated for new commercially significant uses of their works, while allowing users to use their work, the work of authors, on fair terms. Which is why most commercial uses of copyright material are subject to copyright. Now, also, not surprisingly, each time there was a need to adapt copyright, there were calls for the death of copyright. This happens, it's kind of a cycle, happens every time. So just coming to large language models now, obviously, these are a major technological change. It's a technology that can produce commercially competitive content that will most likely displace some human authors, but also help other authors create differently. And the reason that LLMs can do so is because they have ingested, is a term that you hear a lot, the works of human authors. And I think it'd be odd to say that for this change, which is arguably the biggest technological change since the internet, and even perhaps bigger than the internet, copyright was to fail to adapt as it has done before when technology changed. So basically, I think we need to just find a way to make sure that creators and their partners are decently protected while allowing AI technology to progress. It's kind of finding a balance, striking a balance that we've done every time in the past when there was a technological change, and I think it can be done again.
Thank you. And now that we are talking about the AI technologies, we've marched up to this time in our discussion, and there's a lot of ground to cover on how copyright and the technologies connect. We're really focused mostly on LLM technology and a little bit on the diffusion models later when we talk to Professor Shemtov. But what I wanted to see is, there are so many relationships there, everything from exclusive rights to exceptions and limitations. Professor Gervais, would you mind giving us a little bit of insight into the rights that are implicated in these uses?
Yes. So as Babis explained, there is undeniably copying at the training stage. So there's I think everyone recognizes there's a need to copy the original copyrighted works to create kind of a data set that can be accessed more quickly, and then that can also be modified and updated. So there is this original, the copy of the copyrighted works that are then going to be used for training. But as Babis also explained, what's interesting in his explanation is that with the word embeddings, it looks like that in the transformer models, there is a copy, or at least some substantial part of the original copyrighted works that remains, although in a different form, in the tokenized data set, which would involve a second reproduction. And it would also mean that every time you copy that data set, you are making yet another reproduction. And each one would be subject to a separate infringement analysis, including, of course, fair use. And I suspect we'll come back to that later. Now, that's on the input side. Very quickly, we can talk about the output side, and I can say more later. But essentially, when the machine produces an output, it's a pretty standard infringement analysis in the sense that you ask if it's substantially similar to an existing copyrighted work, and whether it copies a protected expression from that pre-existing copyrighted work. In which case, you have established a prima facie infringement case for the copyright holder, and so that is happening. At least it looks like it's happening in a number of cases. I could also discuss the so-called derivative work right if you'd like, but really the main point is all the copying that takes place. And again, it looks like the copying is pretty clearly established, which then means that the issue turns on fair use, unless, of course, the use is licensed.
Thank you, Professor Gervais. And I think if Professor Shemtov is back, we can also ask him to. Oh, thank you. Sorry for our technological issues, but you are back, and we're excited to see you. So I would like to ask you a little bit to amplify a little bit, or to go a little bit deeper into what Professor Gervais was saying about the rights. So he was talking about kind of the reproduction right and all of the copies that are made, but we also have these outputs that Professor Gervais kind of touched on, and they also implicate other things like the public display, the public performance. Could you talk a little bit about the rights that might be implicated on the output side?
Okay, so thank you, and again, apologies for the technical glitch. On the output side, the right of distribution. The right of distribution, public display, and performance. They're all implicated or engaged. When it comes indeed to the training itself, it is essentially copying and adaptations or translations. And just to second what Danny was saying, a copying is taking place at two different levels: the making or the preparation of the data sets, and then the model, once trained, also contains, at the very least, partial copies or translations of the data, the copyrighted data on which it was trained.
Oh. Katie,
I think I was there. So I was going to say that this is an interesting discussion because you've got some of the exclusive rights that are on the input side and some of the output side and some of them that are both, where you've got these kind of reproductions kind of going in. You could do the public display, public performance, or the making available, communicating to the public. So we have a lot of different kind of, it's like a web of how these all work together, it seems. And the questions that arise in that area also kind of bring up the other issue, which is exceptions and limitations. So we've heard a bit about, out there talking about this with other people. It's such a hot topic. Some of the questions about exceptions and limitations, like there's fair use in the United States, in some other countries, fair dealing in some other countries. And to talk about that, I'd love for you both to briefly kind of go over some of those issues. So Professor Gervais, can you give a little bit of information about the U.S. exceptions, limitations, like fair use?
Of course. I just wanted to add on the previous topic a quick footnote, which is there's also the question of who might be liable. Which if you're the producer of this model, or you're the provider of this model, there might be liability. But if you're a user, and as Noam was saying, if you produce something, you may not. That may not be you may not be liable if there's infringement. But if you were to make available, display, perform that output as a user, you might also be liable for that. And so that's one point to bear in mind. So of course, in the U.S., we're talking essentially about fair use. Fair use is essentially still an American doctrine. I say still because other countries are considering it. Other countries have adopted a version of it. So this means that what is legal under fair use in the U.S. may not be legal elsewhere. You have to do a jurisdiction by jurisdiction analysis. So fair use in the U.S. is a four-factor test contained in Section 107 of the statute. But the reality is that there's a ton of common law about fair use, a common law that both preceded the statutory codification in 1976, but a lot of common law since 1976. For example, since the 1990s, actually almost every fair use case decided since then has turned on whether the defendant's use is transformative. This is a very important part of the test. That test is a little bit murky. For example, there's a lot of cases in the Second Circuit in New York concerning appropriation art with artists like Richard Prince and Jeff Koons, and it's almost 50-50 as to what isn't the transformative enough to qualify as a fair use. The thing that's very important to understand here is that fair use is what the courts call an equitable rule of reason, which means, as the U.S. Supreme Court has said in many cases, in particular in the Campbell case, also known as the Pretty Woman case, that it must be applied by courts case by case without bright line rules. And as the court said in another very famous case, Harper and Row, the fair use analysis must be tailored to the individual facts of the case. I would also add to this that in the most recent case, the Warhol case, the court insisted on the potential competition that an allegedly infringing output might be for the works that were copied. And we also know from several cases that commercial use is less likely to be fair. So you have all these things that a court must factor in. If I can just very quickly give one example, I think some of what LLMs are producing are likely to be fair uses, but so again, an example of this would be if a university created a model using scientific articles for a nonprofit research project. I think that would pass the test. But as the court in Warhol also explained, you have to look at each use. So if the university were then to sell that data set to a commercial provider, then the fair use analysis changes. So you can see that fair use is a very kind of both dynamic and then a case-by-case doctrine. It must be applied carefully.
Thank you so much, Professor Gervais. And Professor Shemtov, do you want to talk a little bit about the other international approaches that might be seen fair dealing or the TDM issues?
Yes, thank you, Katie. Just a small addition, perhaps in broader terms, to what Daniel said. To me, it is pretty clear that from a pure economics perspective, when we train generative AI systems, what they do is they clearly leverage copyrighted works and the expressive value in copyrighted works. This is quite different in terms, when we think about fair use, quite different from cases that sometimes people refer to, such as Google Books, where they actually took some small portions of works almost solely in order to identify the location and for a search related purposes. But if we move to other countries' exceptions, and we'll focus on the EU and the UK, it's also interesting to see what is happening, perhaps in Japan, but maybe if we have some time at the end. In terms of exception, the EU and probably the UK are going down, unsurprisingly, the route of legislative exceptions. Text and data mining at the EU, that are governed under Article 3 and Article 4 of the Digital Single Market Directive. In Article 3, the exception applies to reproductions made by research organizations and cultural heritage institutions in relation to text and data mining activities. And that exception applies as long as these institutions, which are not-for-profit institutions, have lawful access. This, in many ways, is equivalent, although the language is different, to the UK only exception. So in the UK, as for now, the only activity which is exempted in relation to text and data mining is this, which is done by non-profit organizations, research organizations, scientific organizations, and so on. But in the EU, it is Article 4 that takes another step and extends the exception to organizations which are commercial in nature, again, for reproduction and extraction, for the purpose of data mining, as long as they have lawful access to the work, and as long as the rights have not been expressly reserved by the right holders, or in more straightforward language, what you need is lawful access, and that the party who is the right owner did not opt out. One last comment, which is interesting. This is being a directive. The directives in the EU needs to be transposed to national law. When we look at the German transposition of Article 3, it contains the exception for scientific research organization. But the German transposition states specifically that it excludes such organizations if they are collaborating with private businesses. If a non-profit organization collaborates with a private business, then they cannot shelter, in principle, under Article 3, and it is Article 4 that they need to look at, where, as we said, a party has the right, or the right holder has the right to opt out. How exactly you opt out, I mean, that can be a bit complicated, and we should not forget, or no, we are not getting into that at this point, that the AI Act also gives the parties or imposes an obligation of transparency. And if you have transparency together with the right to opt out, that means that you may opt out, and you may then look at whether your data or your works have been scraped. And if they did, then you can take the relevant steps in court.
Okay. I think that looking at these kind of global issues, we have different countries, different regions that have different approaches. Some of them overlap and some of them don't. One of the things that most countries in the world are party to is the Berne Convention. So we do have some unifying piece there. And Professor Gervais, do you want to touch a little bit about the 3-step test and how this might be impacted by these uses and these different exceptions and limitations? And the 3-step test, for those who don't know, is a crucial part of the Berne Convention, which is the kind of preeminent foundational international treaty that we have in copyright that puts forth some kind of basic precepts. But Professor Gervais, I'll turn it over to you for a minute.
Yes, well, thank you. I'll try to be brief. So the Berne Convention indeed is the most important international copyright treaty. I think it's about 181 countries that are party to it. That doesn't leave many out. And then the Berne Convention was incorporated into the so-called TRIPS agreement of the World Trade Organization, which means that a violation of the Berne Convention by a country can be the subject of a complaint at the World Trade Organization. Now, of course, the WTO is working, let's say, not very well, partly because the U.S. opposition to making it function properly, but still, the cases are being brought, and there have been cases brought about the 3-step test. So the test is basically it puts boundaries on what a national legislator can do in adopting an exception to copyright. So the first step, very quickly, is it needs to be a special case, which means it needs to be limited and well defined. And I think it's pretty clear you could pass this test as an exception for say text and data mining or LLM training. The second step is a little bit more complicated because the exception cannot interfere with normal exploitation of the copyrighted work. And I apologize, that's the mouthful, but that's the language of the convention. And here, obviously, licensing the rights that you have in a work is very much part of how copyright works. So that there are arguments definitely that could be made that you have to be careful in designing an exception for training. And then third step is even murkier in a way, because it says the exception cannot cause unreasonable prejudice to the legitimate interests of the author or copyright holder. So you can see how lawyers can play with those words. Basically, though, in the simplest possible terms, I think there's definitely a way for a national legislature to craft an exception for text and data mining or LLM training that would pass the test. At the same time, it cannot cover all of it, and this means that the rest, whatever is not covered by an exception, would need to be licensed to be legal. And as Noam was explaining, that's the EU approach to allow under Article 3 certain fully exempted organizations, and then under Article 4. Commercial organizations cannot use content that was opted out, for which the directive makes pretty clear that the intention is, at least the EU intention was to make a licensing regime function.
Okay. Thank you, Professor Gervais. So all of this kind of hinges on the different technology that's used and the different uses. And I think it's a good time to touch base with Dr. Marmanis here and ask him a little bit more about the copies. So we talked about how the copies were made at the beginning. And now that we've heard all of this different information about legalities and copyright, would you take a minute and kind of try to boil down the essentials of the copies? So how are these copies being made, and what is kind of their role?
Yeah, we covered it a little bit in the beginning of our session. But we can repeat since many may have joined a little bit late. So there are copies made at various stages in building and operating a system such as, let's say, ChatGPT, since it's the most popular, but Bard and anything else along those lines is operates very similarly. So apart from the obvious copy of moving the text that you're going to process around, we also have the word embeddings, and the length of the word embeddings can be today in the tens of thousands of tokens, 10,000 words in sequence stored in the system. And lastly, one can also consider that because of the sophistication of the system and the nature in which the training takes place, the actual weight parameters that determine the probability distribution create a copy of what is seen while the LLM is trained. Remember, the LLMs are trained on a prediction of next token exercise. So the way you train it is you take a sequence, which, like I said, can be extremely long, tens of thousands of tokens long. And you say, okay, given all these, what's the probability that the next word is going to be X, right? That's how the whole thing works. And by going through the volumes of text that many are familiar with, the probability for that next token is calculated.
Okay.
And those, so perhaps one thing to comment on those things that have been copied is that they are perpetually used, right? So it's not I copied and it's gone. I copied and it's there.
And it keeps coming, kind of being reused and going back to that well, kind of to deal with the context and whatnot. So we have so far talked about the technology, the intersection with the law, and then how these things are used. And there are the differences internationally, there are the differences in the different regimes. So one of the things that is a possibility to help solve these is licensing. We did have a town hall, our first AI town hall, focused on licensing. If you have interest in that, you can go watch that as well on LinkedIn. But for those of us here now, the licensing scheme is something that could be really helpful here. It could be helpful to kind of harmonize the different uses and the different issues that are around, because if you have a license and it's voluntary, and you can go ahead and make something that's global and whatnot. I wonder if Professor Gervais and Professor Shemtov had anything to say about the potential for licensing to help address some of these issues. And I think I'll start with Professor Gervais, if you might.
Yes, well, there's definitely a business case for licensing here. The fair use path, which is the current path of the AI providers, most of them anyway, are relying, I think, on fair use. Some have explicitly said so. That is a long and potentially very costly path. The lawsuits will take, before all three circuits in which lawsuits are filed, and en banc reviews and Supreme Court reviews and all of that, we're looking at 5 or 6 years of uncertainty and potential massive awards of statutory damages. So I think in terms of resolving uncertainty, in terms of making the situation clear for both copyright holders and users of their works, I think a license would make sense. It would also allow people to clarify issues concerning removal of rights management information, which is a separate cause of action in the US and elsewhere around the world. So basically, to simplify, when you copy a work for training purposes, you remove some of the metadata that's embedded in the work, and that is not authorized. Or there's a way that it could lead to liability, I should say. And then it would also allow some sort of reporting and transparency. There's kind of an incentive right now not to be transparent about what's in the model because of potential liability, which a license would also remove, which would make the systems and the reporting and the I think the situation better and safer for everyone involved. So I definitely see a business case for a license at some point.
Professor Shemtov, do you have anything to add to that?
Yeah, I think generally, and even in a broader context than the specific US context, I mean, one comes across various arguments against the finding of copyright infringement under such circumstances. Many times it will be presented as it's an anti-tech and stuff like anti-tech progress and anti-business and so on. Now, this is not my impression at all. For similar reasons to those pointed by Daniel. I think from a legal perspective, and then he's having my former practitioner's hat on, businesses primarily wish for legal certainty and predictability, a workable transactional model, and reasonable costs and simplicity. Effectively, this is what licensing can provide. So legal certainty, so business can plan ahead, and depending on the licensing model that is offered, they get something which is workable, both in terms of simplicity and costs. So I would almost go as far as say it's a no-brainer.
Thank you so much, Professor Shemtov. So we have some questions that have come through, so we're going to address some of those. And if anybody in the audience has any questions, please feel free to put them in the chat. And if we have time, we will get to them. But I'll start off with one of them that it says it's a basic question, but I'm going to send this one to Professor Gervais. So if the question is, if you've done your training on something that's a set of pirated books, or if you've done something that has been taken at the outset without permission, is that use of pirated content itself a violation? So that is the question before you even get into the trading, I suppose. Professor Gervais, you want to address that briefly?
Of course. I wouldn't say itself. I don't think I would formulate it quite that way, but I would say two things. So first of all, as Noam was explaining, that would disqualify most likely the application of Article 3 if you're a nonprofit in the EU. But if you're in the US, that is one of the factors that would apply under a fair use analysis. And the weight given to that factor is very difficult to predict, but it is certainly relevant in the fair use analysis that the material, if that's the case with a particular data set, like books 3, was illegal. Obviously, the people who made the data set in the first place may have separate liability here, but in terms of training on the data set, I would say that it would be one factor weighing against fair use.
Okay. We also have another question here that talks about some of the challenges that people have. So one of the main challenges for publishers is whether LLMs will provide accurate attribution to copyrighted works from a publisher's platform after training on that material. So the question really there is, this is a question about how do you make sure that people get attribution if it's needed, either I would guess under US law, which is the section 1202, or under moral rights or some other way. Professor Shemtov or Professor Gervais, either one of you want to take that one on? How do you deal with the attribution issue?
Go ahead.
If by attribution, so attribution in relation to the actual training, that if I understand that correctly, that would be equivalent to transparency, right? So the fact that in the EU it is it's mandatory. In the UK, not yet, although my personal feeling is that there is an appetite for that. In relation to the situation in the US, I'll leave the floor to Daniel.
Yes, I think a lot of information is likely to come out in the discovery process and all the pending lawsuits in terms of which material was used. Some providers have been more transparent than others about the material they've used. I would also say my understanding, I don't know if Babis will want to talk about this, my understanding it is possible not on the input side, but on the output side, it is possible to program a model so that it will tell you what it drew from in producing a certain output. If that's correct, technologically speaking, that obviously would be a game changer in terms of for example, if there was a license in terms of attribution. But underneath all this, there's obviously a technological question. Plus, right now, the incentive or non-transparency that is created by all the pending litigation.
Okay. Another question that we have is more of a bit of a technical question. So maybe Babis can also chime in on this one, which is, if the tokenized data set contains partial copies, does that mean a license is required to copy or make available the data set? So as far as, so we might ask Professor Gervais about the license piece, but for Babis, about the data set, can you make a copy of this data set, without having all the copies in? The copies are still made again, I would assume, but I will leave that to you, Dr. Marmanis, to answer.
Yeah, can I go back to the earlier question before we tackle this one?
Sure.
And there are a couple of things that I wanted to note there. So one, to Professor Gervais' comment, the whether it is feasible to create attribution when the overall system follows a retrieval augmented approach, for example. The very nature of the approach is to basically attribute specific elements of the response to its origin. But that is very limited in terms of the attribution, because that is only on the basis of what the response is related to that query, and other elements of works that have been used in the training may be participating in that response that are not, for which there is no attribution to. Is it possible to technically? Well, yes. Is it something that's currently done? And not to my knowledge. That was the first part. And then the second part is there's fundamental difference in the way these things, I think, are trending from a business model perspective that is different from what rights holders of copyrighted materials may be used to in previous models. So, for example, when the internet first came around and the big search engines came around, it was, the business model was that, well, okay, we will give you the material, we allow you to index the material, and the benefit that we get is that the user is coming back to our website for the complete content of the work that you have indexed. I think where we're trending here with LLMs and solutions built on them is that the answer to the question of the user is provided entirely within the environment of the LLM AI system, and that's fundamentally different from what we were used to before. Especially that notion that LLMs will become the kernel of the new operating system. So many people project, Andrei Karpathy is one of them, for example, thinking of the LLMs as being the kernel of an operating system where the interfacing with the end user happens through the LLM, and then tools are built and references are consumed by the LLM in order to completely answer the questions to the end user. So that's that. Now, what was the question you asked?
I think that we actually were running towards the end of the program here, so I think that we have so many questions and so many different topics that we could address, but perhaps we will address them in another town hall, because we are planning another one for early summer. So we will announce that, and if anyone is interested in seeing that, follow our LinkedIn page, and we will certainly post it there. I would just like to take this opportunity to thank everybody, and really appreciate all of your expertise in being here today, both our esteemed panelists and our audience members. And if you are interested in learning more about AI and what CCC is doing, then we have a really excellent resource at copyright.com/AI. So please come visit that at your convenience, and we will have information there. And until the next town hall, it was great to have this program, and have a great rest of your day.
Thank you.
Thank you.
Thank you.